I'm Jeff Fleming, an estate planning and elder law attorney in Altoona, Pennsylvania. Many of my clients, the home is the largest asset that they have. They've paid that mortgage for 30 years and it's paid off, and it is the largest asset. So naturally, their concern would be, how do we protect that if we go into a nursing home or from inheritance taxes when we pass? And so first solution that comes to most of their minds, and I get asked this all the time, is should we gift our house to our child or to our children? And it may be a very viable solution in a lot of cases, but we want to make sure that our clients are making informed decisions. And so let's just take a real quick look at some of the factors. First, for purposes of the nursing home concerns in Pennsylvania, when a parent gifts that property to their children, it is transferring what is otherwise an exempt asset and making a gift to children. So there is a 5-year look-back period and possible disqualification or penalty period if you apply for Medicaid within 5 years of the time of the gift. So be wary of that particular issue. As far as inheritance taxes are concerned, there is in Pennsylvania what's known as a contemplation of death rule. So if you happen to make a gift of your real estate and die within 1 year, it will still be subject to Pennsylvania inheritance taxes. Another concern that we don't like to talk about, but it is a concern, and unfortunately it happens, but when you as a parent give away your home to your child or to your children, then you may have concerns about whether or not you're going to give up the right or the ability to live there for the rest of your life. You would no longer own it if you make a gift, so you need to protect that right to live there for the rest of your life. And there are a number of ways to do that, but that is something that's very important that you discuss. The other element is, what happens if something happens, God forbid, to that child to whom you just gave that property? They die before you. Now your property is subject to Pennsylvania inheritance taxes in their estate. Or if they become subject to a divorce or they get sued, then will the creditors or that soon-to-be ex-spouse have any rights with respect to that property? So those are additional elements that you need to take into account. And finally, there's an income tax issue. When you gift your property to that child, they carry over your basis. And what that means is when the property is actually sold, assuming that it is, then they calculate the capital gains for income tax purposes based on the price that you paid for it, the person gifting the house, which means that you may face a much larger capital gain than if you transfer it at death. In other words, a 20% capital gain is a much higher tax than a 4.5% inheritance tax. This isn't to say that it's right or wrong to make a gift of your property to your children. It's just that there are a lot of issues that you and your advisors should discuss. And working with a professional who understands all of these issues and can guide you accordingly, that's the key to a great relationship. We offer a free consultation to prospective clients for the opportunity to have this discussion and make sure that it is a proper fit, and then we can offer the expertise in the areas that you need. To take advantage of a free consultation with no obligation, please call me at 814-943-5500.